Okay, so we'll go ahead and get started. Welcome everyone to our next webinar. And as you notice, this is a new app that we're using. And so some of the features are different. The main feature that I want to point out is the Q&A button on the bottom of the screen. So this is right below where you can see the Xinova presentation. And you can use this button to enter in questions at any time during the webinar directly into that video and, in that window, and we'll answer all the questions at the end of the webinar. So today our presenter is Xinova IP attorney Rahul. Rahul works with us in protecting our innovators' ideas, whether as a patent or perhaps as a trade secret. So today he'll explain what trade secrets are, what can qualify as a trade secret, and how they are protected. So Rahul, I'll let you take it from here.
Yeah, sure, thanks, Shivani. Can everyone hear me okay?
Yes, they won't be able to chime in, but yes.
Okay, great. Yeah, so today we're going to talk about trade secrets. This is geared towards our inventor community. So, I mean, my objective is to keep this as not to be as legal as I can. So, I'm hoping to keep this at a technical and an inventor level. The idea would be I'll present for about 20 to 25 minutes on the subjects that Shivani had mentioned. What a trade secret is, how do you enforce a trade secret, what qualifies as a trade secret, and then I want to open it up to questions. And I believe that Shivani, you might know more about this, but I believe you can ask questions through the platform, and Shivani will read them out.
Yes.
Okay. Okay, so the first, as an overview, there's four types of intellectual property: patents, copyrights, trademarks, and trade secrets. And trade secrets is what we'll talk about today. We know a lot about patents, especially if you've been inventing with us for a while. Our business previously was based on patents, and the inventions that you would submit, we would file a patent application for and pursue a patent. Or a number of patents throughout the world. Our business has changed over the years, and now we're looking at different ways to protect the intellectual property that you guys submit in the form of solution reports and inventions. And one of those ways is trade secrets. Trade secrets are different than patents. This is there's different statutes and different laws with respect to trade secrets all throughout the world, but generally they have these three elements. A trade secret has to have independent economic value. It has to have value to others who cannot legitimately obtain the information, and it's subject to reasonable efforts to maintain its secrecy. So it has to be a secret. So these are the types of things that can be a trade secret. So it's a laundry list, but these are things over the years that have been considered a trade secret: opinions, technical reports, computer software, manufacturing processes, designs, customer lists, market predictions, formulas, recipes, pricing or financial information, business opportunities. All of these things can be considered a trade secret. Now, again, these whether or not these are considered a trade secret depends on the three factors that we talked about up here. Having independent economic value, the trade secret must have been maintained as a secret, and it has to have value to others who cannot legitimately obtain the information. So these are some really famous trade secrets that you guys may be familiar with. So probably the textbook example of a trade secret is the formula for Coke. It's been around since the 1930s. It's locked up in a vault somewhere. But the actual chemical formula for Coke has been maintained as a trade secret. And that sort of illustrates one of the advantages of a trade secret over some other forms of intellectual property. So trade secret has no duration. A patent in the U.S., patent everywhere has a specified duration. In the U.S., for example, it's 20 years from the filing date. But a trade secret, as long as you're able to maintain it as a trade secret and you're able to maintain the elements that we talked about, can be maintained as a trade secret literally forever. So Twinkies, the The formula for Trinkies is a famous trade secret, WD-40. KFC, the 11 herbs and spices, that is a trade secret. That's also been maintained for a very long time. I think Colonel Sanders wrote down the recipe for the original 11 herbs and spices, and it's kept in a vault in Kentucky somewhere. A lot of people don't know that the Google search algorithm is also a trade secret. So these are all well-protected corporate trade secrets that have, some of which have been around for a long time, that do have a considerable amount of value. So again, I don't want to get too legal, but there's many different ways to protect trade secrets. There's both state law and federal law. Importantly, there was a new federal law that was enacted under the Obama administration in 2016 called the Defend Trade Secrets Act, and so that makes pursuing a trade secret claim a little bit easier at the federal level. One interesting aspect of trade secrets is that trade secret law can also subject theft of trade secrets can also subject one to criminal penalties. Again, that's a big difference between trade secrets and patents. Patents are a civil matter. You can sue someone for patents for economic harm, but for trade secrets, you can also be liable. You can also be criminally liable. And there was a famous case a few years ago where DuPont had a number of trade secrets on the Kevlar technology. So Kevlar, you may be familiar with, is used a lot in police vests. And so there was a South Korean company that was accused of stealing DuPont's trade secrets with respect to Kevlar. So in the end, the South Korean company had to pay $360 million, 85 of which were criminal fines. So trade secrets, the point is trade secrets also can subject one to, trade secret theft can subject one to criminal liability. So the trade secrets definitely have a distinct value, and they're different than patents. In many ways, patents are stronger than trade secrets, but in many other ways, trade secrets offer advantages that patents can't. Number one, trade secrets, like we talked about, have no limitations. You can have a trade secret as long as you maintain the secrecy and the other requirements. You can maintain trade secret protection for perpetuity. Trade secrets, unlike patents, have no registration requirements. So as you all probably know, to get a patent, you have to file a patent application with the patent office, and then there's an interplay between the patent applicant and the patent examiner, and then in the end, the government gives you a sheet of paper that says this is your patent and this is what it covers. There's no such requirements for trade secret. You would get the trade secret immediately as soon as you're able to establish that all the requirements for trade secret have been met. So there's a much more minimal cost to obtain a trade secret, in a sense, than a patent. Now, when we talk about cost, we're familiar with the patent process and the costs associated with that. So, like I said, there's no registration requirements. But if you do want to protect something as a trade secret, there are the costs of maintaining secrecy. And we'll talk about a little bit about this in a few slides, but basically there's costs to maintaining confidentiality. You have to have the right processes and procedures in place. You have to have sufficient secrecy and confidential measures. So there is a cost to maintaining that. There can be large damages awards for trade secrets. We talked about the DuPont case, the Kevlar case. We'll look at the Uber case in a second. And one other value of trade secrets is there's no disclosure requirement. So when you compare trade secrets with patents, the deal you're making with the government with respect to a patent is that you're going to disclose the technical requirements of your technology in exchange for a 20-year monopoly. But you still have to disclose it. In many cases, the inventor or the trade secret owner does not want to disclose it and wants to keep the competitive advantage to him or herself. And when utilizing your invention as a trade secret allows you to do that. Whereas with a patent, like I mentioned, you would have to actually disclose it. In the software and hardware space, trade secrets are becoming more popular because in the last few years, patentability, especially in the United States, with respect to software and hardware, has become much more difficult. There was a Supreme Court case a few years ago called the Alice case. You may have heard the term that, check if the patent has any Alice problems. That case basically made the requirements for patentability for certain software inventions more difficult. So utilizing a trade secret in cases where you can't get a patent, it can be an effective strategy. So along the lines of the value of a trade secret, this was in the news earlier this year. You may have heard of the Uber and Waymo case. Now, this is typically something you would expect to see in a patent litigation. This technology involved the light detection and ranging sensors that you find in Uber's self-driving cars. They're called the LiDAR sensors. So in this case, Uber acquired a startup, Auto, which was formed from a former Google employee. And as you know, Google owns Waymo. The allegation was that the Google employee had taken a number of Google trade secrets related to this LiDAR technology when he started his startup. So when Uber acquired the startup, they had effectively acquired the trade secrets that were Google trade secrets. And again, Google owns Waymo. So Waymo sued Uber for trade secret misappropriation based on these 8 trade secrets related to this these LiDAR sensors. In the end, the case went to court, and in the end, the 2 parties settled. But Uber, as part of the settlement, gave Waymo $245 million in the amount in a payout which was based on its Series G shares. So a couple of interesting things about this case. This kind of illustrates how trade secrets are now front and center in the technology economy. This illustrates how much money can be involved. I think this illustrates that not everything has to go the way of patent litigation. This is a pretty significant technology in driverless cars. So I think trade secret enforcement can be a very effective way to protect your technology. Now, when it comes to enforcing your trade secrets, you have to demonstrate to a court that someone has misappropriated your trade secret. And misappropriation is acquisition, disclosure, or use of a trade secret of another by a person who knows or has reason to know that the trade secret was acquired by improper means. Improper means includes theft, bribery, misrepresentation, breach, inducement of a breach of a duty to maintain secrecy, or espionage through electronic means. Now, the thing I want to point out here is that what misappropriation does not include. So one defense to trade secret misappropriation is independent invention. So it is possible that I could have a trade secret. I could be tinkering in my lab. I come up with an invention, and if I keep it a secret, and somebody else, Shivani, could come up with that same invention in her lab independently, I don't have a cause of action against her for trade secret misappropriation because she didn't misappropriate it. She didn't steal it. Now, when you compare that to the patent regime, that's very different. the patent regime rewards those who invented first and who went to the patent office to protect it. So in that same scenario, if I had gotten a patent and I patented first and I went to the patent office to protect it, I could sue Shivani for patent infringement because I went to the patent office first, I invented it first. But like I said, for trade secrets, if Shivani were to invent it independently, there would be no case for trade secret misappropriation. Another big difference between trade secret enforcement and patent enforcement. So what's not improper means? We talked about independent invention, reverse engineering. So this is something if you, now you guys are all inventors and you guys are submitting inventions that we are reviewing. We are now protecting some solution reports by ways of trade secrets if there's a reason to do so. But that can only be done if we can protect it as a trade secret. So a trade secret it can't really be enforced if the actual technology can be reverse engineered. If someone can look at the technology and reverse engineer it, then there's no point in keeping it as a trade secret. There was no theft there. So for example, if you had a wheel or something like a wheel that was easily reverse engineered, then it's unlikely that we'd be able to maintain it as a trade secret. Compare that to like the formula for Coke, which is intrinsic in the soda and involves a lot of chemicals that someone probably could not reverse engineer. And then the last part of this is public disclosure. So if something is public, it can't be a trade secret. If something's found in literature, if something's found in a commercial brochure, anything that's publicly available cannot be the subject of a trade secret. So that's something that we consider as well when we're evaluating inventions. And that's the same with respect to trade secrets or patents. I mean, if something is known, it can neither be a trade secret nor a patent. So there's different ways to protect trade secrets. There's specific trade secret laws. We talked about some of them. There's unfair competition laws. There's contract laws. There's non-disclosure agreements. And there's non-compete agreements. So now this is an important point, and so there's a difference between trade secrets and confidential information. Now, trade secrets, if you look at this crudely designed Venn diagram that I constructed, trade secrets are a subset of confidential information. So confidential information is anything that you deem confidential, any secret. But a trade secret, now remember the elements, a trade secret has to have economic value. So simply because you keep something as confidential doesn't necessarily make it a trade secret. All information that qualifies for trade secret protection must be confidential, but not all confidential information qualifies for trade secret protection. So again, it's very important. One of the elements that we talked about was secrecy. You have to keep a trade secret secret. So there's different ways to doing that. Most companies, including ours, have very distinct procedures that they follow to maintain trade secret protection for their trade secrets. So here's this slide lays out a couple of different ways to protect your trade secrets. You would want to restrict access to that information, either physically or digitally. Limit access to personnel who only need to know the information. You definitely want to require confidentiality agreements. Anyone that comes into contact with that trade secret would be required to sign an agreement saying that they will not divulge that trade secret. In any documents that lay out the actual trade secret itself would probably need to be marked as confidential. So there has to, if there ever comes a time where we would need to enforce a trade secret, we would have to demonstrate that we took these reasonable efforts to maintain secrecy. So yeah, we talked about this. It's good practice to put some sort of confidentiality tag on all documents that disclose the trade secret. Okay, we talked about this. Okay. So now, our evaluation process requires us to review the solution reports that you submit and sort of assess what the best way to protect it would be. Would it be a patent? Would it be a trade secret? The one thing to understand is if we're talking about the exact same technical information, we do not have the option of patenting and keeping as a trade secret. The reason for that is because once you file a patent application, in most countries, that patent application will publish at some point. In the US, it's 18 months from when you file it. Once that patent application publishes, it's no longer a secret. And so we can no longer then pursue it as pursue trade secret protection. What we do and can do is we can file a patent application and see how it goes. And before it publishes, before that 18-month period in the U.S., we can abandon the application and say, well, we want to see how this plays out. There's still further development that needs to be done. We will abandon the patent application, and then we will go back to keeping it confidential. But once it publishes again, we don't have the option of protecting a technology as a trade secret. Now you can keep parts of a technology as a trade secret and other parts as a patent. This is commonly done. So for example, the Coca-Cola syrup formula that we've talked a lot about is a trade secret. But Coke also has patents on the beverage composition and beverage preservatives and other things that go into its soda. So you have a patent, you have a patent portfolio that protects certain aspects of its beverages, and then of course you have the trade secret that protects its formula. And it's actually very common in technology licenses that you would have a package of patents and trade secrets. These are called hybrid licenses that protect the technology and license the technology. These are sort of the main very, very easy tips to consider as you're out there inventing. Is when you're inventing and you're submitting something to us, maintain the confidentiality and secrecy. If it's something that we protect as a trade secret, we would need to maintain that secrecy to keep it as a trade secret. Now, this is different than what you're probably used to with respect to patents. So if you file a patent application, once the patent application has been filed, we've protected it, and you can then go out and speak about it publicly or try to sell it or license it, so on and so forth. But that's different with respect to a trade secret. And then if you can, when you're inventing, if there's ways you can invent so that it cannot be reverse engineered, that will allow us to protect it as a trade secret. Again, if it's reverse engineered, we don't have that option. If it can be reverse engineered, we don't have that option as keeping it as a trade secret. So that's kind of a very general overview. In practice, we are reviewing your solution reports and in our evaluation process. The vast majority of cases we're still protecting as a patent, but I think it's nice now that we also have this other means to protect the asset or the technology, if there's an advantage to do so. I guess one note regarding the next RFI webinar, it's formulating stable natural colors for beverages, and that's coming up on July 10th. So anyways, yeah, I hope that that sort of at least gives you a sense of what trade secrets are. We have about 20 more minutes, so I'll open it up to questions if anyone has any questions.
Perfect. Thank you, Rahul. We have a couple questions in already. So first question is from Pavel. And he asks, can know-how for a patent be considered trade secret?
Yes. Yeah. Can know-how for a patent. So know-how is something that could be the subject of trade secret protection. What know-how know-how is more of a colloquial term. Trade secret is the actual legal definition, and that is what you would assert is the trade secret. When you say know-how for a patent, I guess the only thing that I would point out though is if it's something that's disclosed in the patent, once the patent publishes, it cannot be a trade secret for the reasons we discussed, because it's no longer a trade secret, because it's no longer a secret.
Okay, our next question is from John Cho. What happens if you obtain a trade secret prior to it being designated as such? Are you then bound by the same legal recourse of the trade secret?
So what was the question? What happens if you obtain a trade secret before?
Before it's designated as such.
What happens if you obtain a trade secret before it's designated as such? Well, I guess so. The important point there is there's no designation of a trade secret, and that's sort of one of the differences between trade secrets and patents. You don't go to a government office like the patent office and say, I would like a trade secret. What happens is you have a technology, you keep it secret, and then you assert that it's a trade secret, and you would, I guess it would, your proof that it's a trade secret would be when you go to court. And then you'd have to prove all the things that we discussed. You'd have to prove that there was reasonable means to keep it a secret. You'll have to prove that it's not public. You'll have to prove that it has economic value, all those other things. But there's no, I don't think there's any point at which it's designated as a trade secret. It's a trade secret as soon as you maintain all the requirements.
Okay, so our next question is, suppose if we get local recipes online on YouTube, mostly in the local language, and you use that information to make your solution strong, would that be a breach of trade secret?
So if you get local information from YouTube with respect to recipes?
In this example, yeah, so local recipes, and you get them online, and you use that to make your solution strong, would that be a breach of trade secret?
No, because if it's available on YouTube, then it's publicly available. So anything that's available on YouTube cannot be the subject of a trade secret. Now, it could. I mean, there could be patent protection on it, which you wouldn't know until you do a patent search. But as far as trade secret wise, if it's available on YouTube, it's not a secret.
Okay, and our last question so far is, you mentioned that reverse engineered inventions can't be a trade secret. But if you then file a patent instead, can you sue the original trade secret owner?
Yes. So if you now we're talking about patents. So let's say you have something. Let's say you have a new wheel. Let's say wheels are known. Obviously, you can't patent a wheel. But let's say you invent a new type of wheel, or someone invents a new type of wheel, and they try to keep it secret, but you try to file a patent application for it. Now, if they keep it secret, they can we talked about the reasonable means that they have to keep things secret, agreements, physical barriers, and so on and so forth. So if you actually go in there and you steal their invention, then they have a cause of action for you for trade secret misappropriation. If it's public, then it's not something you really can file a patent application on anyway. If it's shown that it's accessible, then it's not something you could probably get a patent on anyway. What could happen is independent invention. And this was the example I was illustrating with me and Shivani inventing the same thing. So let's say Shivani invents something, a new wheel, and she doesn't do anything. She doesn't. She tries to protect it, but she tries to keep it a secret. But I independently, without stealing it from Shivani, go and file that wheel, that new wheel. I file a patent application for it. I go through the patent office, and then I get my patent on it. I can then assert that patent against Shivani because I independently acquired the wheel. I independently invented the technology for the wheel, and there was no trade secret theft, and I have a patent right to it. And even though it can be reverse engineered, reverse engineering does not preclude my right to a patent. So, anyways, that's a very long answer to. There is, if someone else, reverse engineering does not preclude someone from getting a patent.
So just a quick follow-up to that. If something can be reverse engineered, then presumably it shouldn't be a trade secret.
Exactly. That's the whole thing. Yeah. If it can be reverse engineered, there's no point in attempting to keep it as a trade secret.
Okay, we have a question. What if a former employee developed his invention with knowing his former employer's trade secret? Is that still a breach? And so kind of a follow-up to that is, how would he be employed at all in the industry then?
Wait, say that again. What was the question?
What if a former employee of a company developed an invention knowing his former employer's trade secret? Is that still a breach?
Well, I guess it would focus on. So I'll let's look at both sides of that. So if the former employee took trade secrets and utilized technology from the former employer, that would be a trade secret misappropriation. Effectively, that's the Waymo versus Uber case, right? So in that case, Anthony Lewandowski, a former Google employee, downloaded a whole bunch of files that had to do with the LiDAR technology, and then he started his own startup. So in that case, there would be trade secret misappropriation. Now, it's a much more difficult case if you're talking about what if someone generally knows some technology and that leads him to invent something else when he leaves his former employee. That's a case that a court would have to really assess whether or not he's actually utilizing the trade secrets or he's actually independent. He's invented something independent of that trade secret.
Okay, and so the follow-up to that was, how would that person be employed at all in the industry? And I think you answered that, but the idea is it's complex and essentially has to do with how knowingly the person took that information, if it was a trade secret.
Yeah. Well, how he would be employed? Well, so his new employer may have no knowledge of what he knew or didn't know at his former employer. So they may employ him, but it would be his old employer that would assert the trade secret misappropriation claim against the former employee, and that's exactly what happened in the Uber Waymo case.
Okay, and we have a follow-up to one of the earlier questions, which is that if information is available on YouTube, it's available for use since it's public, but what if that YouTube video is then removed later, and so it's no longer available in the public domain?
It's still public. It was once public. Once the cat is out of the bag, then it's public. That doesn't. Once something is public, you can't take something that's in the public domain and then try to protect it as intellectual property. That's a patent, a trade secret, any form of intellectual property. Once it's public, it's public.
Okay, so that's all the questions we have so far. We'll hang on for another few minutes. So again, there's a Q&A button at the bottom of the screen. You can click on that and submit your questions. I believe there's also a feature to ask your questions anonymously if you like. Okay, so we have a question. How does Xinova protect a trade secret and monetize it, since they can't file for a trade secret?
Yeah, so we would protect it just like anyone else would protect a trade secret. We'd keep it confidential. We would maintain secrecy. The whole evaluation process from when it's submitted to when we decide whether or not to accept an invention is kept confidential. And so we would protect the confidentiality. As far as how we'd monetize it, we'd monetize it in the form of a license, likely to one of our customers. We have an engagement, as you all know, we have an engagement with Pepsi, which is one of our biggest customers. We do have certain trade secrets in the portfolio that we've acquired for Pepsi. So it's something we're already doing.
So I'll wait another minute or so. Oh, just got a couple more questions. So how many trade secrets has Xinova awarded?
I think in our portfolio we have a few. I think it's something we've recently begun doing, so it's not that many. I think it's less than 10 in the portfolio.
Okay, our next question, and maybe our last question, is most of our contracts have awards when a solution is patented. But as you said, our biggest client is PepsiCo, and ideas given to them is more like in trade secrets. So how will the inventor benefit? And I'll just clarify that actually that in the contracts, if something's protected as a trade secret, the same award is given. I believe, Rahul.
Yeah, yeah. So I'll refer you to Giovanni or your IDM as to how the inventor gets compensated. But I believe that's right. I believe that that the trade secrets are just as just as any other solution report is.
Yeah, and just to clarify, I think some of our older contracts may not have that language, or may not be specifically stated in there, but the new contract absolutely should state that trade secret as well as patents get that final patenting bonus. And a question on what is international law regarding trade secrets? Is it the same as the US?
No, no. Every country has its own trade secret laws, just like every country has its own patent laws. Um, protect and we generally looked at this particular um, this particular presentation was very U.S. centric, but generally those elements are the same from country to country. You have to keep it as a trade secret. You have to keep it as a secret. Can't be reversed, so on and so forth. But every country has its own laws and different ways to protect trade secrets. Some countries are viewed as less protective of trade secrets than others. I think the United States is now viewed as more protective because we have this federal statute called the Defend Trade Secrets Act. But every country is different.
Okay, and a follow-up question to earlier, the 10 trade secrets you mentioned by Xinova, were they awarded as part of new or old contracts?
I have no idea. Yeah, I'm not. If it's I don't have much visibility into what the inventors get when we accept something. That would be a question for your IDM. But if it's about inventor compensation, I believe we have compensated all of our inventors for things that we've kept as a trade secret.
Okay, that's all the questions that we have, and I think we're hitting the 45-minute mark here. So thank you to all our viewers and for asking really wonderful questions. And thank you, Rahul, for a great presentation. I think this is really informative and helpful to everyone.
Okay, thank you. You all have a good day.